Hi, everyone. Thank you for coming. This is the AALS, American Association of Law Schools Teaching Remedies webinar, and we're excited to be doing this today. I hope, are going to be moderated by Portia Pedro, and she is, we hope, going to be zooming in a bit. I don't want to keep everybody waiting. Should we start with some of the material, or should we wait 5 minutes and see if there are others showing up to watch, and hopefully Portia showing up to lead us through this discussion today? We'll give it a few minutes.
Maybe you should do the introductions. You're the least important anyway, and should be
okay ready. Yeah. So let's do that. The sort of mandatory introduction portion of the proceeding. I think we were mainly just going to say where we are, and given that there have been a couple moves, myself included, we'll each state where we are and how long we've been teaching remedies. I think those are the critical things that Portia wanted. So I'm Caprice Roberts, and I've been a former chair of this section. Lucky to do that because this is a wonderful group of people, and I was happy to say yes to do this when John Golden asked. Thank you very much. It says I'm visiting at GW, but that actually ended a few days ago, although I am using their Zoom today politely with permission. But I joined the faculty at Louisiana State University. I'm excited about the move to Baton Rouge this summer. That's haven't done that yet, but it's forthcoming, like my publications as well. I've been teaching remedies, I think, since 2002, which now seems like a really long time. I'm a former student of Doug Rendelman. I see he's on the call as well, so shout out to him. He sort of engendered my passion for it early on, and I never gave it up, even though it is a challenging but really rewarding course. So that's it for me.
I'm Doug Laycock at the University of Virginia. I'm emeritus at Texas. I've been teaching remedies for 45 years, which really seems like a long time. I chaired this section a couple of times in my youth, way back in the 80s. Caprice didn't mention that she has a major casebook, Rendelman and Roberts, and I also have a casebook, Modern American Remedies.
Thanks.
Hi, everybody. I'm Saurabh Vishnuvat. Until a few days ago, I was at another school, Texas A&M. I've just joined the faculty at Cardozo Law School, and I've been teaching remedies for about 6 or 7 years now. I will say I'm a current adopter of Professor Laycock's excellent book, and I know that's one of the many things we'll discuss. I'm the current chair-elect of the section, and so I've had the pleasure of working so far this summer with John Golden. Look forward to the years ahead.
Hi, I'll jump in here. I'm Tracy Thomas. I'm at the University of Akron. I've been teaching remedies for 26 years. I think Portia also asked us how we've taught remedies. I've taught remedies as a large bar class. I've also taught it synchronously about 10 times and now asynchronously about 6 times. So different formatting there. I am the lead editor on the Remedies Public Law Casebook with David Levine and David Young with West.
I'm Michael Morley at Florida State University College of Law. I've been teaching remedies for about 8 years now. I've learned a tremendous amount from my co-panelists here, and I use Professor Laycock and Hasten's casebook there. I've drawn tremendously on Professor Roberts' materials, and I've also had the opportunity now to teach remedies both in person, online via Zoom, and have tried different formats like more of a traditional lecture class, something more approaching a seminar class. And I'm thrilled to have the opportunity to chat about teaching remedies with you guys today.
Thanks, Michael. It looks like at least John Golden has joined the conversation. So John, you missed my thank you to you for setting this up. I think you put the wheels in motion, at least a lot of the wheels, in addition to Portia. And so I should have mentioned thanks to Doug Laycock for mentioning the Remedies casebook with Doug Rendelman. I also took over the Dobbs treatise, which was quite an undertaking, and many of you have sent me fabulous comments to that with an eye towards maybe there'll be future editions. That seems hopeful, but you know, I keep that in mind, but that was a wonderful opportunity to kind of keep learning about remedies because there is so much to cover the field. I'm supposed to be doing a mastering remedies for Carolina Academic Press. Maybe one of these esteemed panelists will join me in that endeavor. That's a student guide. But that's it for, I think, what each of us sort of bring to the table. Of course, Portia also teaches remedies. I think she's taught a seminar at Boston. And I've also taught multiple formats by video and not, multiple schools. I think Doug Laycock as well. So we can talk about that as we go. So our plan, I think, for today is to kind of go through a series of questions to each of us, different questions pointed to each professor to some extent to give them an opportunity to kind of focus on that area. And then we definitely hope to open up this conversation to all of you, because you probably have many, many questions, and there's so much that we could cover. So
I hope I could just break in just for a moment to say, I'm
Sure.
Alan Schwartz, I teach at Yale Law School, and I've never taught remedies. So I think I'm sort of a unique person, but I do teach contracts in commercial law and mergers and acquisitions and a bunch of things in which remedies play a large role. And I really want to mainly listen and see what people who teach remedies as more of a standalone thing have to say, and see how it relates to the way I try to fit remedies into the substantive things that I do. So I'm happy
Wonderful.
to be part of this.
Yeah, thank you, Alan. And again, each of you that has joined, I recognize many of the names. Some of the names we don't recognize, but you can reach out to any of us via email, at our various schools. I think Remedies is one of the most welcoming groups, and we appreciate that there are a lot of professors who might teach a 1L course or an upper level course that has a Remedies component, or that you might be teaching a freestanding remedies course. All of us either sought it out or were tasked with it. I know that happens sometimes too. People are sort of talked into teaching it, and we encourage you to take that leap if you have the opportunity. So until Portia appears, I don't know, she might have something going on. So let's just go, I think, go with this. And we're going to start with Doug Laycock and get you thinking about, all thinking about what is the import of the materials that you select. Of course, we all have our preferences and biases, but Doug can sort of say this, given that he has probably the one of the preeminent in the field. So he's going to tell us about how the courses changed over the years. Of course, I recommend his law review article to you about sort of the development of teaching of the course of remedies. But let's hear from Doug and see what he has to say there.
Well, I guess I've been teaching. Doug Rendelman, who is on the call but not on the panel, has taught it the longest. I guess I've taught it the next longest. There have not been dramatic changes over the years. People teach this course in very different ways. I've had some evolution, but I've had some experiments and some backtracking, but really no big changes over all those years. I worked out the content of what I thought belonged in the course in the first few editions of my casebook. I've substantially improved the organization over the years. I hope I've improved the exposition. I'll let others decide that. I dropped some things that became obsolete as the Supreme Court kept shrinking federal remedies. There are remedies that used to exist that no longer do. I haven't added much. There's already too much to cover. In the classroom, choosing what out of the book to cover has varied somewhat over the years, but again, not all that dramatically. In recent years, I have focused more and more just on the basics of damages, injunctions, and restitution. I've pretty much abandoned the back of the book. I don't like that choice, but I think it's the right choice. I haven't taught contempt or attorney's fees in a fair number of years now. The reasons for that are less than precise, but the biggest reason is a belated appreciation of what we lost when we collapsed the first year curriculum. Alan's torts and contracts courses used to be a year long, and many teachers covered a fair amount of damages in those courses. You couldn't count on students to remember it, but they had some significant exposure to damages in torts and contracts. Now those courses are just a semester. You're lucky if your students had a day or two of damages. Sometimes they didn't have any. And I've decided I just can't skip over any of the basics anymore. That obviously happened a while ago. I was slow to react. I was attached to teaching some of those things in the back of the book, but I think the basics are more important. I've also gone from attempting to do an all Socratic class to doing a mix of Socratic and lecture. A few years of all lecture and back to the mix. That's more about me than it is about Remedies. I think I'm really good at explaining things. I'm at best a mediocre Socratic teacher. It's partly about Remedies in the sense that there's a lot to be covered. And the longer I spend in the field, the more I know about it. I can take them deeper, more levels into the argument by explaining it instead of trying to drag it out of them. Of course, they don't remember everything I tell them, but they don't remember everything they hear in a Socratic class either. I believe that the more context we give them about the rules in the principal cases, the better they'll understand that rule in that case, and the more likely they are to remember some of it. We probably shouldn't do all lecture, but in the second and third year, we should not be afraid of lecture. Some people teach remedies with problems. For the most part, I don't. I use problems in a few contexts where math is especially salient. I use a problem for net present value when I teach that. I use a set of problems for the tracing rules and restitution. Other than that, it's a traditional case book with principal cases and notes and comments. Some young teachers are afraid of teaching remedies because so much substantive law becomes relevant, and they think I don't know all that substantive law. How can I cover all this? Be assured you know more about all that substantive law than your students do. It'll be just fine. And you don't need to know all those other areas of law very deep. And what you don't already know, you'll pretty quickly pick up enough to be able to handle the remedies issues that grow out of those cases. They are, of course, connected. The remedy has to implement the policy, the underlying substantive law. But you will be way ahead of your students on doing that.
Thank you, Doug. I want to say I'm Caprice again, and I was just sort of pinch hitting, but I'm so glad that our esteemed moderator has arrived. So Portia, just to catch up, we gave brief introductions of ourselves, and then we kicked off with Doug telling us a bit about his course, but let's hear from you and your introduction so we can sort of recap from there.
Most sincere apologies. We had a last minute job talk scheduled on Friday for today, and I got caught up if they started talking about remedies. So I'm very sorry that I am late, but the job talk did not go awry. And so what we were doing, it sounds like you were at the point, you've done the introductions. I'm Portia Pedro. I'm at Boston University, and I've been, and I am fortunate to be able to teach remedies as one of my courses. So it seems like you did the introductions and we're starting the topical discussions. And Doug had started the beginning of that portion. Okay, perfect.
Yes.
All right, nice. And so then are we at the point of opening it up for the subsidiary questions I had on Doug's point, or are we moving on to?
We're moving on to your next person.
Okay, perfect. All right, so what we had next was for Michael Morley. What suggestions do you have, or what problems have you seen in preparing a syllabus? To me, there's just so much in remedies, right? You've got equitable, you've got the private law areas. Some of it's covered in some 1L courses, some is not. So if you could just start off with what you've seen there and what's worked for you in that scenario.
Great, thank you very much. So when I was putting together my syllabus for the first time several years ago, and over the times I've revisited it in large part again based on helpful suggestions and feedback from many of the members of this panel. In my view, I think there's four big questions that you need to face, especially if you're thinking about structuring it the first time. The first is, and they all deal with what you want the course to focus on, because that in turn is going to have a major influence on what you put in the syllabus, how you allocate your time in the syllabus. The first big thing I think you need to ask is, do you want this to be a primarily private law course? Like when, typically when we think about remedies, right? Remedies in the context of, common law causes of action, calculating damages, getting equitable relief, things like that. Or do you want to go bigger and have it be something of a combination of private law and public law and leave room for remedies like Bivens claims, for example, getting into whether the court will recognize private rights of actions under different statutes and sort of loop into some of those public law questions that might start getting into the fringes of administrative law, get into the fringes of constitutional law. And right then and there, especially for most of the major casebooks on the market, that's going to affect what chapters you're going to select, what topics you're going to focus on. And I think that the course is going to come across very different depending on that big picture question that you answer. A second kind of related concept is I think about, do you want this to be Caprice tweeted, don't forget restitution and unjust enrichment. Obviously, huge part of any remedies class. I do not mean to omit that at all. Second big question, which again I think is somewhat overlapping, is do you want to focus on what I will hopefully non-pejoratively refer to as small r remedies, meaning remedies that come at the end of the case, versus big R remedies, does legal recourse exist in the first place? And again, you start to get into questions of recognizing private rights of action, getting into more conceptual issues of should there be, how should the government determine between making something a civil matter versus a criminal matter, private enforcement versus public enforcement, and those sorts of bigger picture remedy questions about the nature and existence of remedies, you wouldn't necessarily get into to the extent you're approaching it closer to like a black letter law type class, hewing more closely to the restatements, including, of course, the restatement of restitutions. I'm quick to add in there. A third big picture question I think you need to ask yourself is, how do you want to approach this? And this I don't necessarily think is an either or type question, but in my view, I think there are three main types of approaches. One is you can have a class that tends to focus on math and formulas and providing different types of formulas for different types of examples. And I think that there are actually some case books that are better tailored to that approach. A second type approach is, yes, obviously, right, there's some minimal degree of formulas that inevitably are going to arise, but is a more conceptual approach, right, talking more about the doctrine, the doctrines in the abstract, getting into more policy rationales, things like that. And then finally, I think you can look at remedies from something of a theoretical perspective, right? Getting into some of the law review literature, talking about the relationship between rights and remedies, right? The fight between rights essentialism and remedial equilibration. Getting into the cathedral when you get to equity, right? Getting into the cathedral model, some of the critiques of the cathedral model, the Coase theorem, things like that. And so again, how you're going to allocate your syllabus is going to depend in part on how do you want to teach this class? Do you want to do it more in terms of nuts and bolts? Do you focusing around formulas? Do you want to do it more about the concepts? Do you want to do it on a more theoretical level? And again, I don't think it's an either or. I think you could draw from all three buckets. I think a good class probably does involve a mix of all three. And the final big picture question I think you need to ask yourself, which again, Professor Roberts pointed us to, is how much restitution do you want to put into your class? Because for a lot of these other subjects, like damages, for example, particularly tort damages, contract damages, even to a certain extent, the standards for injunctive relief, I think the students will have had exposure to that. Not in the same level of detail, not necessarily in the same level of depth. Many of them might not even necessarily remember it, but they will at least have had exposure to those concepts in their other classes. With most, if not all of the, or at least close to all of the topics we talk about in restitution, this is their first exposure to it. In some contracts classes, there might be like a case or two alluding to unjust enrichment, right? Some of the case books still have like the doctor who comes across the unconscious patient, and that's pretty much it. That's pretty much the beginning and end of right quasi contract, unjust enrichment, restitution. It's sort of maybe a half a class in contracts. And so one of the big opportunities that a remedies class presents is to teach restitution and expose students to restitution, expose students to the other types of equitable remedies, like constructive trust, equitable liens, these subjects that don't really appear in other classes that they're going to take. And so drawing that balance, I think, is the other big issue that comes up in preparing a syllabus. So just to sort of sum up with kind of where how I drew this approach, I start out with a class or two giving students a theoretical basis. I have them read excerpts from Darrell Levinson. I have them read excerpts from Monahan and from Sager, where we talk about the nature of rights, the nature of remedies, the relationship between them. We actually read an old Supreme Court case about whether abolishing debtors' prisons violates the contracts clause. Spoiler alert, it doesn't, but that case was all about the relationship about how changing the remedy doesn't impact the existence of the right. I then go on to spend about 40% of the semester on the common law remedies, going tort, contract, property. And I like to spend a lot of time on the boundaries between the common law areas, like particularly contract versus tort, focusing on the notion that a lot of times the practical difference between whether you have a tort cause of action, a property cause of action, a contract cause of action, is the nature of the remedy that's available to you. And so focusing on those boundaries and sort of those gray area tough cases between the different, what we often think of as silos of the common law, is very helpful. I briefly touch on other types of damages, punitive damages, nominal damages. The next big chunk of the semester then turns to equity, where we get into the obviously injunctions, other types of equitable relief. I spend most of the remainder of the time, about a quarter of the semester, on restitution, and then spend the last two classes on what I refer to as technical issues. So these are things like enforcing judgments, preserving assets. I do get at least a case in on attorney's fees, and of course the American rule and the exceptions to that. And that's always something that I feel like the students, it sort of gets rushed in there at the end. I would like to spend a little bit more time on kind of these nuts and bolts. You have a judgment, now what do you do? How do you go out in the real world and enforce it? And so, this is certainly a work in progress. It's something that changes over time, evolves over time. But at least as of now, that's the balance that I've reached. And drawing on both my main casebook, which is Professor Laycock's, as well as other supplemental readings, then I balance out the syllabus to achieve that time balance.
And I think so. I think what I'm going to do, which is a little bit different than some of what I talked about before, is we'll go through these questions with people, and then maybe at the end bring up and see if there's people who do some of these things differently, to have more of a discussion after we run through this. I got distracted temporarily because when I looked for where Saurabh was on my screen, so he wins Rate My Room for this Zoom session. Just in many ways, is there even greenery back there? Just the lighting, all of that. But so the next question is for Saurabh, and on this, within remedies, for me, looking at teaching it for the first time, I thought, whoa, this is actually one of the most, in my opinion, like maybe hidden or unexpected landmine of places for things that people actually really feel strongly ideologically about, right? I think a lot of people might expect it's constitutional law or something like that, but it's a little bit more on the surface maybe, or at least the students might expect it. So what I wanted to see if you could talk about for a little bit is a couple things. So how do you work around teaching topics within remedies that are further outside of your own research experience, interests, right? So some of it I think Michael touched on a little bit with kind of are you doing the math or are you not focusing on the math? But then also, how do you deal with some of the more controversial issues within remedies, or some of those ones that tend to divide a bit more along ideological lines? And as we go through, also still with some ideas of talking about this more at the end, if somebody after Saurabh addresses that wants to kind of to chime in before we move on, feel free to either raise the hand in chat, or I guess on your screen. I think I can see most people, and we'll go from there. Okay, thanks.
Great, yeah. So I will say, on the point of specialization and teaching sort of outside my own comfort area, It's something that I've had good luck with, and also some helpful preparation with, insofar as I teach other trans-substantive, just two, in addition to remedies, I teach Civ Pro and admin law, and they have a similar kind of sort of landmine prone flavor to them. And I try to bring that out fairly early in the course and let the students know to expect it, particularly in Civ Pro. It's a semester-long infomercial for why you should eventually take remedies. And so let me sort of begin with that question of specialization. When I'm crafting my syllabus, I'm aware, in addition to all the terrific points that Michael made, I'm aware of generally two other things that are also going on from my students' perspective. One is that remedies is tested in different ways on a variety of state bar exams, the multi-state bar exam, the uniform bar exam. And so, some of my students, maybe a great many, may be taking it for that reason and not because they want the sort of intellectual discourse that I would love to engage in with them. So there is a sort of degree of just nuts and bolts. Here's how you get your client what they're looking for at the end of the day. And that helps both temper the depth versus breadth question of specialization, and to some extent, how much time I think is appropriate to really devote to the controversial subjects, which are fun and important, but do cut against before we get to the really deep controversial stuff, do you know how to enforce a judgment at the end of it? So that trade-off is something I'm very mindful of. And then the other thing that I try to get a good sense of either early in the course or perhaps even ahead of time is how many of the students who are taking the course are 3Ls versus 2Ls. When I first taught remedies at Texas A&M, my very first year, it used to be a 3L only course. You could take it as a capstone, and it was a terrific capstone, but that's the only way you could take it. And I sort of discovered that, and my very first sort of act on the curriculum committee that year was to propose that 2Ls be allowed to take it. And I was very candid, like, look, I'm selfishly trying to increase my enrollments, but I think it's also a good thing to do as a 2L. I took remedies as a 2L, and it completely changed how I saw the rest of the law. And I took it in time that I could sort of bring that additional insight and perspective to bear. So, if you've got a lot of 2Ls in the course, then you could probably take a little more liberty with the controversial subjects. You could be a little more theoretical. You could explore the connections between different areas of specialization. 3Ls, they're probably in it for the bar. They've probably checked out at least a little bit. Those kinds of things at the margin are helpful to consider. The first true answer to how to teach outside my subject area is a terrific paper that Sam Bray published in the Green Bag in 2015. And it's called On Doctrines That Do Many Things. And it's a terrific exploration. It's very short and incredibly well written. It's just a really delightful exploration of single purpose versus multi-purpose doctrines, things that highly specialize to one area versus things that are a little, sort of second best around the margins, but allow an experienced user, like a judge who's been on the bench for many years, or a professor who's been teaching a subject for many years, to say, okay, look, this doctrine won't get you exactly what you want every single time in the way that a tailored tool might, but it's really adaptable. And because you've got facility with it and judgment and experience and intuition, it's the sort of thing you might prefer rather than 7 different single-purpose legal doctrines. Right? And in a trans-substantive course, that kind of perspective is very helpful. And so I encourage all my students to read that fairly early in the course. I also try to put them in my perspective, in my shoes a little bit. I'm primarily an IP lawyer, and so the case that I love to sort of pick on and teach against to some extent is eBay. It's controversial. It involved all kinds of sort of doctrinal challenges, but also it was about patent trolls, which students have read about in the popular press and so on like this. So by teaching a case and the controversy that surrounds it, the analytical and sort of intellectual controversy that surrounds it, I can show them that here's what all the IP lawyers in the room were thinking about, and they weren't really talking to a remedy specialist, and here's what happened. Let's talk about that. Now, what would you be doing if this were in your field of bankruptcy or your field of family law or something like this? And so by teaching them a few areas of specialization, I can generally put the students at ease that, look, you're not going to be an expert on everything, but you can at least understand where the perspective of the specialist is coming from versus the generalist. So that's the point about specialization that I would say. Now, as far as controversy itself, taking into account what my students' incentives are, what they're trying to maximize. The first time I consciously tried to introduce a controversial subject into my materials was during the first of the travel ban cases during the Trump administration. And as fate would have it, it was just around the time we were about to start teaching, we were about to start covering injunctions, and in particular, nationwide injunctions. So, this couldn't be better, more tailor-made for the subject. I had them read a couple of the pleadings, and I tend not to assign a lot of law review articles, but in this situation, I made an exception. I assigned sort of a couple of pages out of each of 2 or 3 articles on how nationwide injunctions work, and then just said, okay, relatively little about injunctions at the moment. We're going to do an injunctions exercise in Professor Laycock's casebook. That's, the fact pattern is right there. It's all there in detail. You write your own draft injunction, and then I grade it and give you feedback based on the sort of model answer. We'll get to all of that, but just based on what I've told you, what you've read, and now these case documents, what do you think you would advise the judge to do? You're the law clerk. What would you advise the judge to do? And then we talked about it. And I try to put them in the perspective, the position of the law clerk rather than the judge, because I'm getting hung up on, well, I don't want, policy to cloud my answer. Whereas if you're a law clerk, I feel like, you have at least a little bit of leeway, depending on how much your judge tolerates that, to say, well, here's where I'm coming from, judge. And you can take that or not take that. So it gives them a little bit of discipline. It's not entirely a political science discussion, but there's room for ideology to play a role. I've tried to update the hypo is something, it's not exactly ripped from the headlines every semester, but something that's either current or relatively recent. At least 1 or 2 of those every semester. If we have time for more, we can incorporate them. But what I want them to take away from the coverage of controversy and controversial subjects is sort of 3 main things. One is that there are these ideological divisions in places you might not expect. And so you should be attentive to them and to the distributive consequences, whether the law and economics and efficiency approach is what you care about, or sort of dignitary or retributive, sort of whatever your philosophical starting point. You should be able to see what the other methodological orientations are and be able to argue in a way that your audience would understand. That's one thing. A second is that you have to look beyond your immediate the immediate needs of the client. Yes, you are an advocate, but you're also an officer of the court, and you have larger responsibilities to society. And being able to sort of deal in the vocabulary of controversy as a lawyer is an important social skill, not just a professional skill that you need to cultivate. And then the third, and this is the most elusive, so I try not to lean too hard on it, is that there are limits to how much yielding to opposing viewpoints you will feel comfortable with, and how much yielding might be appropriate. Not all viewpoints are created equal in terms of validity, and not all viewpoints are argued in the same amount of good faith. So you need to recognize, or at least train yourself to try and recognize a good argument and an effective argument on the one hand versus a clever but not necessarily sincere argument on the other. I try to make it explicit again. You're not going to master this in 1 semester, but it's at least worth sort of starting to think about it. And if you're too well when you take the course, then hopefully you have a little bit more time over the rest of law school to put that into practice. So I try to address controversy a little bit in that way. So The one final point I'll make in closing, and I mentioned this earlier, teaching against a case. I try to be as candid as possible. I don't think of myself as a particularly strident classroom instructor and sort of bringing a lot of political valence to any discussion. But I will tell students when I'm teaching against a case. Here's what the Supreme Court decided. Obviously, I'm not going to come out and say, they're idiots and they got it wrong, because I've yet to see a situation in which I did think they were idiots. But maybe here's a situation where I think they could have done better, or here's what's inconsistent with what those of us who've been following the subject for a long time might have thought the intuitive answer was. Because changes to the law don't sort of walk up and announce themselves, at least not very often. And so recognizing that a really transformative moment in the law is taking place may not be easy for students to do. It's all new to them. So pointing out, here's where I think you should be skeptical of what the court is saying, or here's another explanation for what the court might have been trying to accomplish. And it's most salient in Supreme Court cases, but going to happen at other levels as well. But I'm candid about when I'm teaching against a case or sort of resisting the conclusion of a case, so students develop that intellectual skepticism as well.
All right. I am going to admit some short-sightedness in maybe moving too quickly in my rate your room awarding. I do think we have some other contenders. I think Deirdre Smith is one, and Tracy, our next panelist is another. And so for Tracy, what we're moving on with you is, how are your classes structured to facilitate student learning? And I know your book, you have a lot of problems as materials. How do you incorporate those within the classroom? Is it something that's mostly in the class? Are they looking at them outside of the class, discussing them within the class? Do you flip your classroom in some way so that they do a lot of that outside of the classroom, and the classroom becomes more discussion? Just what does it look like for you in the classroom?
Yeah, I do sort of feature problems in my class. And this really started just a few years into Remedies. I've been teaching for 26 years. I think I was in my third year. And as several have mentioned, with upper level students, they're kind of tuned out by this point. And it seemed to me they really weren't getting that this was such a great transition class for practice, and that it was integrating much of law school. And they were missing that because they were just trying to use the same easy ways of memorizing rules that had kind of coasted them by. So it was really started off just to get them interested and engaged. And this was a long time before we had a lot of learning theory. So we didn't have information about flipped classrooms 23 years ago in as much as we do today. So this is a little more obvious than at the time. But the idea was to get them interested, to also connect the practice. So when I think about learning, what do I want them to learn? The doctrine, the rules, but to me, the art of Remedies is really in the application. I once made a list of rules in Remedies, and as we've been saying, they're sort of multifaceted. It was really just one rule for all injunctions, whether you make the first factor a little bit different for a TRO or a preliminary, but there's not that many rules. I mean, maybe 20. What there are then in new so many different ways to apply that. So the problems really bring that out. They let you take what seems easy. The scope of injunction matches the scope of the harm, or vice versa. Scope of the harm matches the scope of the injunction. Well, that seems easy until you try to match that, right? How you try to put that in a case, how you litigate that, how you get all these different opinions. So what the problems are, first, what problems do I use? I use, and you can really use anything. I use a lot of bar essays because A, they're easy, and B, they're going to be testing the information. That's how one way they're going to need to have this information. I use the performance test section as well. So I tend to want to really get mastery in the classroom. So I do really 3 main units plus attorney's fees. So at the end of damages, we have just a review day. And so they'll usually do a performance test as well as some quiz questions. So otherwise, for the daily problems, I use the essay questions. I also use current events. So I use the travel ban case. I use Henrietta Sacks. I use a local Ponzi scheme enforcement we had in town. I use a lot of current events that I write up, and students really like those. They've been following those, they've seen those, and those last for maybe 5 years until that current event is no longer in their current mind, right? Or so those do often need revising. So I have done these problems. I've used them all sorts of different ways over those years. So I've used them as hand them out in class, used them as discussion, broken into pairs, broken into teams, used them as a mediation assignment, had them turn them all in, not had them turn them all in. And let me tell you where I am today and what I think works. I mean, one way though, I am now teaching it asynchronous, which I think Remedies is an ideal course for asynchronous in the flipped classroom, because these problems and the practice piece really do that contextual applied learning. So what they do now is they see a video lecture from me, usually about a half an hour, of the rules and the key cases, videos, some graphics, and then they have the problem. And so if it's an bar essay problem, so what, maybe 2 paragraphs, and then they have to write the answer and upload it. Once they write that answer, a model answer and or a rubric, so it could be an outline, it could be a points, it could be an actual written out model. I do both. Sometimes the bar gives you the model, sometimes I rewrite it, because the bar models are just above average answers, which is like a B-. It's not really the right answer. So, and sometimes I do both, right? This is what would be good enough on the bar, but this is what a full correct A answer is. So you get the learning correct, but then you also get the dual, what else, how else do you need to know this information? Then once they get that model, I do a couple things. Sometimes I have them self-evaluate. Now that you see the model answer, write me a paragraph or grade yourself. That is now immersed in learning theory. There's all sorts of information out there now about how self-driven learning, I mean, we know this as lawyers, but they have to tell themselves what they did wrong. And it is a huge learning curve. At first, they just say, I did okay. And then you say, well, I need a paragraph. I need more from you, or I need you to give me, why are you giving yourself 5 out of 10 points? But after the first couple of times, they really start to see, oh, I wasn't precise. I didn't state the rule. I missed the facts. I jumped to the facts. I missed the clues. They really start understanding that self-evaluation piece. And then I will sort of, sometimes I spot check. I read, I mean, I have a huge class, so I have 140, I have 2 sections, 140 students. So I either spot check and review their reviews. I grade several throughout the course. I don't grade them every week. And again, it's not to make it easier for the professor. That self-evaluation is the heart of the problem method. That's where the learning happens. So part of it, they do need to hear from us, what's right, what's wrong, what am I getting? But they also need to start learning to do that for themselves and see what a right answer, you know, however you're defining that would be. Some of the problems are much more theoretical. So we do a tort reform. What is tort, you know, engaging with the policy issues of that. So that time they're writing me more like policy paper, a short 2-page policy paper. So you can change the problems to get at the intellectual issue, the deeper issue, you know, whatever, however you want that to be, a white paper, a press release, or things like that. I guess the final, and then I guess sometimes I have them discuss this, grade each other's, and you can do that online or in class. Sometimes for the end of each major unit, we can get together as a team and negotiate, like a property damages. I have a NEDA problem, a trial ad problem that's released. And so they represent both sides, and we do a Zoom virtual negotiation of the settlement of the case. I think the hardest thing about using problems is getting the students to understand how important they are. You have to make them the primacy of your class, or they will ignore them because they're used to traditional classes. They get that in trial ad or dispute resolution, we might be using problems, but in their doctrinal courses, you read the cases, that's what it is. And you maybe read some of the notes, but this other homeworky stuff, they sort of skip or they don't think is important. So what I say up front, this is super important. This is your client walking into your office. This is what you do as a lawyer. You don't get the rules, you get the client, you get the story, and then you work backwards. So I say that. I put it on the syllabus. The problems are the most important thing. You should devote most of your homework time, I don't call it homework, most of your out of class time to preparing the problems. When we were live, I would say we will spend, and then I did spend about 50% of the class on the problem. So I call on a student for the problem, have them recite their answer. I'd have a second person. Now, what would you add or change? I learned not to say what's wrong with the first person. You say, what would you add? Next person call on, what would you change? So now you're getting 3, 4 people, giving them an outline of the answer, and then we can start talking about it. I do the same thing online. We can do that through a discussion, or you can do that through building a class model answer. But you make it the focus of the class. And so I tell them on the syllabus, I tell them up front, I tell them that this is the key to success, that people who are successful in the class and successful in the bar with Remedies get this problem. This is how you really put it all together. And so even with all of that said, for many years, you will see 60% of the class hasn't prepared the problems. They know all the cases, and again, it's just so different, or they think it's just going to be a 5-minute hypo, not that it's really the meat. So if you want it to be that way, you should do it. The other thing that's different out there in problem method is when you do the problem. Do you do it as a review, or do you do it as part of the homework assignment? So you do it pre-learning before you've had the class discussion. I've tried a little of both, but the learning theory is really that the problem is part of the initial reading assignment. It's not just a review after the fact. It's part of incorporating the cases, the rules, and the application. So they read the assignment from the casebook, and they do the problem as their homework. Then they come to class and see the lecture. Now online, they can kind of mix that up, right? But if you were in a live class, they come to class with their outline of their problem, and then we put that together and grade that and divide it together as a class. Online, it's a little bit more separate. They will have seen the videos in the middle, but they're still working through that. And then, so online, it becomes a little bit both. It's both the pre-learning and the review. So online is really both. You don't have to choose, you can have both of those. So, and that's, again, if it's just a review, it becomes a little bit harder to manage your class. So we have today's class on temporary restraining orders. They do a problem. You come back the next class if you're live, and you start with that as a review, but that takes up so much time of that next class if you're really going to get into discussion, that then you're trying to get to your next issue. Well, now let's talk about, we're moving to declaratory judgment. You lose that nice piece of doing the rules, the cases, and the problem all together in one class. So, I mean, again, now you can find lots more people writing on the pedagogy of learning to see why that all enhances and reinforces problems in many different ways. So that's problem method, at least how I've been doing it.
And then next, we're going to turn to Caprice, and I'm going to ask you to talk about how you evaluate students in terms of, if with an exam, what does the exam typically look like? What types of questions do you have? And just some of the why in terms of how you do that part of it.
Thanks so much, Portia. This has been fascinating already for me to hear what everyone else is saying. And I wish I had the opportunity to basically teach from each of the case books. I think that would be enormous fun and a challenge. I've had the great opportunity of starting my teaching career at West Virginia and teaching there what was then, as Michael said, a capstone type of course in SARA. And a capstone course meant you were getting all the 3 Ls, and they were having sort of that expectation of right before going into bar exam moments as well. Since then, I've taught it in big sections and small sections, and each time is very, very different. And I find that much like, Doug Rendelman, who taught me, I'm realizing you can't cover as much as you want. So I sometimes am covering less and less. And then I think in line with what both Michael and Sarab talked about, sometimes you want to bring in these hot topics because students are expecting to talk about it. I think they come to the course sometimes saying, well, are we going to do, what's going on with the sort of like injunctions in the news, something like that. So you have to kind of balance that. And the test has to balance all that too. Sometimes I've done along the way different things. I don't always do like a full-blown midterm or anything, but in terms of like final exam moments, which is I think what your question is focused on, I've done everything. I started out very traditionally, and I still kind of, my heart sticks to that, which is essay exam. I prefer to have that be 100%, but I've taught this course at UNC and Florida and a variety of other places. And a couple of them sort of were really pushing that you start including multiple choice. And then there's some schools that you're just teaching those very, very large classes, and or you think it's worthwhile for a bar exam moment. So I've experimented with multiple choice, and I think I need to get Tracy's, I still never figure out how to get access to whatever databases of fabulous things are out there. So we should probably share those links again about how do you get the multi-state performance test, and how do you get, whether you're modeling off of it or actually using it. I think there is value to that. But what I found over time is trying to stay true to yourself, stay authentic to how you taught the course. Don't ever use somebody else's thing entirely, because it won't go with how you taught the course. What have you emphasized all semester? What are you trying to get them to do? And for me, I teach the course both public and private. I want them learning a lot about equity and equitable principles. So I'm making sure that I'm testing that. I want them thinking about the theoretical underpinnings, but also the very practical things. So sometimes they're very small things like those practical points that could be good for multiple choice, right? Something where you're looking kind of at a more sort of yes or no, not yes or no, but where you have sort of like an A, B, C, D type of answer. You want to put things that are very doctrinal into that bucket. For me, when I'm doing the essay, I'm much less interested in, for me, when I'm teaching it, the sort of like getting doctrine 100% correct, as much as I want to see, especially if it's closed book, which I've done both closed book and open, and I can talk about that more if people want. But if it's closed book, let's say they, maybe even miss an element on a multi-pronged test or a comparison of a sliding scale test versus some other injunctive test. I want to see how they try to apply it, how they use the different source materials, to push and pull against that. I'm always looking for balance in answers, no matter which way you come out ultimately, that you are seeing what those counter arguments are. That's for me one of the most important things. I also have realized in the same breath that you can't teach everything, you also can't test everything. If you try to test all of it, at least I've found you will get very surface answers, and that makes me depressed at the end. So write the exam that gives you the answers you most hope to read. And for me, no matter where I've taught across the sort of spectrum of schools, in terms of like, sometimes people think you can only give a very hard exam at a very top flight school. You can give a hard exam everywhere, but you're going to get that range of answers. You're going to get some students that blow you away, and you're going to get some students who aren't seeing what you're ultimately getting at if you have something that's a bit hidden or more opaque. So if you really want them to bite into it, you have to tell it to them more directly. And sometimes that means I still love to have a question on an essay exam be a much more thought piece, like big picture, like something I start with on the very first day. Traditional maxims, for every right, is there a remedy? I want that addressed. And I want that addressed by using the different materials throughout the course. So sometimes that's shouldn't be a surprise to them. And I don't think it hurts that they know this is the kind of thing that they might see, but they're also going to get something else. If that's one question, then another question would be much more sort of remedies. It's not really like hiding the issues at all, but it might be issue spotting and doing that comparative analysis across a couple big areas that intersect. And I think my panelists have talked about that, right? The intersection, that's what really I love in terms of the theory and the practice, the intersection between contracts, torts, unjust enrichment, getting them to see that all of that's at play. And then this is where students might say I'm sometimes not as nice as I seem, which is I just say analyze. Sometimes I do that. And I want to see, as an upper level student, I'm trying to teach them discernment. how can they figure out, it's not going to be the best written essay if it's a timed one, but can they figure out, can they tell me, even if the order isn't exactly as they'd hope, will they tell me, I figured out halfway through what the most important question is, that really this all hinges on blank. That's what I'm looking for. Can they sort of see that there are this cluster of things that are coming together, that the client has told you, as Tracy said, like the client comes in with the story, how do you kind of reverse engineer the whole thing? Maybe in real time in a timed exam, you might not get it perfectly written, but you've got some sort of gut reactions of the sort of fault lines you need to be thinking about, and what.
Okay, bye.
And I hope that wasn't for me. And what's going to be dispositive, right? Like what can they see that? Can they discern it? As I said, I'm always including equity as a big portion of it. I'm always having a question that's dealing with unjust enrichment and restitution. And I do encourage, I think I said that earlier, even if that's something that isn't your subject matter expertise, that don't be afraid to kind of like dive in there and try to teach it. And I think one of the things that I've learned is there are areas I have been nervous about because they weren't sort of like my strong suit, or not where my scholarship might be focusing on one given moment. But if you teach it slowly and really just like the cases are so generative, the problems are also so wonderful for taking you through these thorny issues. And I think that's what I'm trying to put ultimately into an exam. I said I've also done multiple choice. I don't love to do it, but I've done it again if the school really had that preference, and or the class was so large and I was nervous about how can I cover everything. I think for remedies, I wrote them myself, which I know, I've attended some of those courses about how do you write good multiple choice. And I think it is. It's not an easy undertaking if you're going to try to do it. You have to kind of see how they go. You have to try to test them out. You have to make sure they're worded in ways that are no sort of ambiguity, latent ambiguities in them. And the other thing I'll mention on the fact patterns, I tend to be more creative. I do things that are drawn from the semester and sometimes from hot issues, but I don't ever, I don't put anybody we know in the fact patterns. I don't use gender. I try to, and that's more because I'm trying to make sure they know who I'm talking about, because you can sometimes get lost in the fact pattern. There's a lot going on. So I'm always trying to sort of use the name and make the names very different. Different from each other, but also not just a standard name of like a student that could be in the class. I'm trying to pick something unusual. They know that going in. And those are things that are perhaps quirky to me. But the last thing I'll say is that I remember taking Doug Riddleman exams, and I learned while taking them. And that's part of what I'm trying to do with the course. I recommend 2Ls take it, as Sarb said, because it changes the way you think. And if you write a really good essay exam, it can make you realize you're learning while you're doing it. You're figuring something out still because you haven't put all those pieces together in exactly that way once you've sort of studied the whole course. I can talk more about that. I think that Tracy has the best advice, I think, about how do you sort of like make sure that students are with you the whole way and not just doing that sort of like final exam moment. I've tended to still be primarily a final exam moment. I have counted participation before. I sometimes have students do a sample fact pattern and write answers in real time. I've had them write answers outside of class, and I've had them share them, usually anonymously, but share them, read them for positives and suggestions. And then sometimes I'll have them do a competition where they're picking like top answers for sort of little mini awards, but that's when I've had time to be more creative. Last thing I'll say is I've had the also luxury of teaching a full scale remedies course and then following it up with the students who really wanted to go on to, I think we titled it advanced remedies. Sometimes that was more restitution focused, which I know Doug has taught a restitution course, and I recommend that as well. Or I've taught seminars that are remedial discretion sort of focused. And that's been, again, a luxury, but has its own, I have very different recommendations for how to do that. But I'm happy to, answer any questions. And it looks like Tracy's put what I wanted. We used to have a website, or maybe it's still on AALS, with like, here's some syllabi and here's some exam samples, but we should think about whether that would be good to sort of collect after this webinar and share with everyone if people aren't following the chat closely. Is that good, Portia? Did I not address anything you'd like?
I think that's perfect. And I think what would maybe make the most sense in trying to make sure we open it up for discussion now is if I'm thinking maybe we'll work our way backwards through some of these topics, but also feel free for anybody who has a question or wants to share what they're doing or what they're thinking about, feel free to raise your hand in the chat, or say something in the chat, or raise your hand. So I think one thing I'll say as we open it up is also if there weren't general introductions, right, of everybody. So when you're talking, if you just say, who you are, what school you're at, that type of thing. And so I'll say, as we are going through, my first thought is let's talk about this part of it, the assessment part of it. Do people do different things with assessments? Do people do midterms or some type of other assessment along the way and really like it? I will admit something. I do papers, and my remedies class is a paper class, even though it's not technically a seminar. And so I gear some of the end of the class to that. But now I am more interested in doing some of the exam part of it from hearing people talk about it. So just let's start. And I see Scott.
All right. Thank you. First of all, I benefited from this. I've taught remedies. I'm at Ohio Northern University. I've taught it for maybe 5 or 8 years. I never had it in law school. Someone had to teach it, so they asked me to teach it. I used Doug Laycock's book. I went to Virginia. Doug is at Virginia, and it's a great book. It's probably the best case book I've ever used in any class. It's almost self-teaching. The students like it, et cetera, et cetera. But the reason I wanted to come today was how to write a good final exam. And Caprice was talking a little bit about that. And so I was pleased to hear that other people struggle with that. So that makes me feel a little bit better. But one thing I do that I haven't heard other people say is, in order to be as comprehensive as I can be, I also have a section on my exam where I give like terms like punitive damages and just ask them in a paragraph or so to define it and then say why it's important for the course. And so that helps with coverage. But I've also found it impossible. I also teach con law, and it's hard, at least for me, to write issue spotting essay questions because, as everyone knows better than me here, the remedies is just essentially a series of separate things. And so I'll have a short fact pattern on one of those separate things, and then another on another one of those separate things and things like that. And then I'll also usually have some kind of policy thing what I find great about Doug's book is the choosing remedies part, where he draws from his Oxford monograph on the death of the irreparable injury rule. And that really blows their mind because, as Doug did in his book, he flipped it. He said, you're taught in first year that you can't get equity unless the legal remedy doesn't work. And that's actually not, according to Doug's stuff, it's not true. And so we deal with that, but I've just been babbling for a second. But Mike, the reason I'm here today is I just wanted some tips on how to write a better final. That's it.
Portia, let me speak to the exam question. This is not the news you're looking for. The older I get, the harder I find it to think of good exam questions. But one of the things I figured out earlier is there are only about a half dozen good questions in any course. and you permutate the facts and you change the names, but it's basically the same issue because it has to be an issue that is sufficiently arguable that students can respectively come out either way and they have something to chew on. If it's a one-sided issue, it's too obvious. Early on in my teaching career, I had the same reaction in Remedies that Scott just described, right? That these are separate pockets and you can ask a set of narrow questions, but it's hard to get good coverage that way. And it's hard to ask an integrated question. Two reactions to that. For a while, I experimented with multiple choice. I sweated blood writing those questions to make them clear and to make them test higher levels of knowledge and understanding and not just be black letter nuts and bolts. And the only way it was possibly worth all the time and work it took to write them was to keep them absolutely top secret and use them over and over for years. And eventually I quit using it and went back to all essay. But what I did find is if you are strategic, you can think of, you can create fact scenarios where there's more than one plausible remedy, where maybe they have to choose the remedy, or maybe they have to combine remedies. There's some ongoing conduct and there's damages for the past, but there could be an injunction for the future. There could be a damages claim and a restitution claim. IP fact patterns are great for remedies exams because it's easy to create a fact pattern where all three are plausible. You have damages, you can have restitution, and you can have an injunction. That would be my advice for trying to think of more integrative questions.
Yeah,
The other thing, one more thing I do with my exams, I give them advice on answering exams, and it's grown to be 3 or 4 single space pages. And some of them actually pay attention to it and write better answers. And most of them ignore it. But we shouldn't test their ability to guess what we're looking for. I tell them what I'm looking for. And I forget who it was, maybe it's Caprice who talked about, you get disappointing answers at lower tier schools. You get disappointing answers at Chicago, Texas, Michigan, Virginia, and Yale too. That's the limit of my experience, but there's just an enormous range of quality, and the time pressure that we usually create in our exams brings that out. And you get terrific answers and terrible answers and everything in between, no matter where you teach.
Yeah, and I just to echo that, I definitely wasn't saying that the poor answers were coming from some of those lower tiered schools, but I was saying you get a range at no matter what. You get some fabulous answers at some of the lesser ranked or lesser esteemed than others. But great questions from Scott, and I think maybe when I was first doing it, I was seeing it in that discrete way. But I'll echo what Doug said. The way I test essays now, I very much view it as all connected. And so I am picking things that are on that hurdle where you've got a blended topic. So intellectual property being a great example, I almost always test it because it's a wonderful to sort of get you into 3 or 4 different buckets, not all the buckets. And that's why sometimes, again, the multiple choice can help for what you were doing with short answer. So I understand what you're doing there. But I find that there are intersections and that you can find a way to draft towards that. But again, it requires that if you prefer for them to have a certain order to the answer where it's not just a shotgun through everything in a jumble, then you may have to direct them more in how you put the call of the question at the end of an essay like that. But I can think of whether I have any that are worth sharing, but I do, maybe Doug is also correct that sometimes you have fact patterns that are reminiscent of earlier ones you've written, but you've tweaked some things or updated some things. So I have done that some too, because I have some favorites where it's like kind of law and equity overlaps and issues there. I like to do disgorgement because I want to see how they can grapple with that. Only a few times have I done sort of more discrete ones, and every once in a while students have a harder time with something that I'm trying to sort of directly put before them, which would be like an economic loss rule. But even those have like sort of contracts towards, there's the intersection again, that I think is so helpful. But let's see if others, I don't know if others had answers to that. I'll let them speak.
And I think what we have, I'm gonna turn to Sarab in just a second, then I have David, Levine, and Paul. And what I want to say in terms of turning to Sarab, one piece of advice I got for multiple choice questions, if you're not drawing from the database, was to draft 2 questions after every class. And then that, and just no matter what. And then you have a bunch to use. And I think it goes along with Tracy's advice about making something tailored to the percentage of time that you spent on it. Because I sometimes don't know exactly how long, I'm newer at this, how long I'm going to take with certain topics and kind of where students are going to be more invested. So I do that. And so I see, so I'll say Michael wants to say something on the prior topic before we move on, and then I'll go to Sarab on multiple choice before turning to David and Paul.
I just want to say to the extent that one of the challenges that you face in trying to put together an exam question is drawing on different strands of what you taught and integrating different strands of what you thought. One awesome way I found of doing this, and I try not to put it on every year so it doesn't become too predictable, but one of my standard go-tos on finals is fraud, because you get into the possibility of having a voidable contract. So you give the students the opportunity to sue on the contract. You give the students the opportunity to seek different types of relief outside of the contract. You give students the opportunity to loop in the possibility of tort-based causes of action. You give students the opportunity to contrast tort-type remedies with contract-type remedies. And of course, depending on the facts of the case, since you are or may be in contract land, depending on how you spell out the fact pattern, you could even use that as an opportunity to bootstrap into equity and to bootstrap into considerations of an injunction and specific performance. So those types of issues dealing with like grounds for challenging the existence of the contract. And like I said, I think fraud is the best way, just because it also aggressively loops in tort there, but is one way of putting students in the position of having to compare and contrast different remedial options and integrate different subjects that they learned over the course of the semester.
Let me turn to Sarab for talking about multiple choice.
Great. Yeah. So I'm a big believer in multiple choice questions, in part because for the sort of bulk of my career where I've taught in the state of Texas, it's been tested on the Texas bar exam and now on the UBE. So the way I generally do it, Portia, the advice you got, I think is terrific, and it's advice I received as well, and I followed it. And what I did is generally 1 or 2 exam questions that I intend to use on the exam, but also a third relatively stripped down, simpler version that I'll use in class. Because the way I write multiple choice questions, it's great for teaching them how to unpack the doctrine and the idea of learning from the exam, as Caprice pointed out. This is the stuff of formative assessment. I will give them a multiple choice question and say, okay, look, the issue spotting has been taken care of for you if you do the following things. First, before you read any of the hypo, just the last sentence or 2 of the hypo is going to be the call of the question. Read that first, then read through the answer choices. The things that the answer choices have in common are what the question is probably about. And the way in which the answer choices differ from each other is what you're being tested on about the subject of the multiple choice question. Okay, so there's your issue spotting right there. Before you've read any of the facts in the hypo, you already know what to look for, because I'm telling you either the answer choice is something like plaintiff wins because A, plaintiff wins because B, or defendant wins because A, defendant wins because B. Okay, so if you sort of permute your answer choices according to one axis of this is the angle of the doctrine I want to test, and the second angle is the practical result that has on the remedy or the outcome of the case or whatever, you've got 4 answer choices right there, 2 times 2. And I've already told you in the answer choices that it's a choice between A and B and how A and B results lead to the result. So you already know to look for that. Now go back and read the hypo, and it helps you avoid red herrings. It helps you sort of recognize a red herring when you might see them. So I take them through not just how to answer a good multiple choice question, but also how to sort of hack a multiple choice question, as it were, and really sort of figure your way around it. What that does is A, familiarize them with my testing style so there are no surprises. B, it gets them thinking about ways in which a topic might be tested. What are the different angles of this doctrine that might be brought into the permutations of the answer choices? I also, and this is a little tougher, but I sort of do it repeatedly over the course of the semester. I'll show them that two of the answers are usually easy to eliminate if you know a little bit about the subject and have a sort of superficial understanding. What's left is the right answer and the almost right answer. And the more you do these, the more you'll start to see, and there's some examples and explanations from the Aspen series that do a good job of this. And this is really where I got the sort of intuition to begin with. They explain why the right answers are right, but also why the wrong answers are wrong. And once you go back through a practice multiple choice, if you can spot for yourself as a student why the wrong answers are wrong, you're in a much, much better position to develop your outline as the course goes on, to do practice questions. I've had a couple of students come to me close to the end of the semester and say, I've written a bunch of my own multiple choice questions to try to approximate how you might test me. Could you take a look at these? And that's a future professor whom I'm probably going to be plagiarizing 20 years from now. But if you can get them there, you're in very good shape. But that's the sort of approach I've taken to multiple choice. And just finally, as a pragmatic point, I think, in a class of up to 40 to 45 students, the amount of time you save in writing really quick essay prompts will cost you later in grading those essays that come in, right? Conversely, if you put all the time up front in writing multiple choice questions, then grading is super easy. You just run them through the Scantron. But that only works up to a point. And I think that point, sort of anecdotally, is about 40 to 45 students. A class that is substantially larger than that, if you've got 60, 70, 80 students, multiple choice questions scale much better than essay questions do. And so to that extent, at the margin, one or two more multiple choice questions and one or two fewer short answer essay questions will give you much greater returns to scale, just as an exam writer and an exam grader. So for what that's worth.
Okay, I'm going to add two things from the chat, and then we'll turn to David and Paul. So Patricia was asking, or was saying that Patricia asked students to explain their answers for multiple choice questions on the exam. And then Suzanne, I don't want to say your name incorrectly, was asking if anyone assigns students. Said Sue? Okay. Sue, yeah. If anyone assigns students to draft multiple choice questions, not to use on an exam, but to help them work out the hacks and doctrine, which is, I think, something along the lines of what some of Saurabh's students were just doing on their own. So let's turn to David and then Paul.
Hey, thanks, Portia. Thanks to everybody. I'm David Levine. I'm at Hastings. I'm Tracy's co-author. A couple quick comments, and then I was going to raise a topic for discussion. One is I like to ask students to bring in the remedy of the day because there's so many things that are out there. Just today, specific performance with Twitter, but there's so many of them, and it helps the students to think about how these things integrate, and you can use them. You can easily use the material that they come up with. Secondly, in terms of Doug saying, where can you come up with good exam questions? My secret is state appellate cases because they tend to tee up relatively limited issues. And if you find one with a dissent, then you've got plausible arguments either way. Those are gold. So I'd suggest that. And then the third, the topic for discussion is, I guess we had a brief mention of controversial topics, but how do you bring in DEI? And the one I'll mention is the question of damages, whether with personal injury cases, whether you pay any attention to race, social class, gender, religion, et cetera. And it can cut both ways, but if people have other ideas about where it can come in, I think it fits in many, many places, but I'll just raise that one and I will end there. And thanks a lot for putting on the seminar.
And so we'll turn to the DEI question is out there for diversity, and then we'll turn to Paul. Somehow this has ended up seeming like we could have had a whole session just on exams and assessments. But let's turn to Paul.
Yeah, hello everyone. Thanks so much for this opportunity. And my question, by the way, I teach at University of New Mexico School of Law, and my question is related to David's question. So my question is, I'd like to get ideas on how to weave in topics related to critical race theory, even though that's such a latent term, related more to socially conscious way of looking at the law. One entry point that I found in the Laycock book is the Hatalay case, which is one of the first cases on the book, and that provides a great entry point. And the other thing I do is, in the context of damages for wrongful death and the 9/11 Victim Compensation Fund, I have my students think about how courts should value a human life, and that has been amazing in getting traction for great discussions, but I'll be happy to hear other suggestions. Thank you.
Paul, I do exactly the same thing, and it's very early in the course. So I'm glad to hear that on that value of life. I think it opens up such a fabulous conversation, the 9/11 fund. And now if you want to mention to students the Netflix special that was on Ken Feinberg, right? Was it called Worth? Is that what it's called?
Worth.
I think it's called Worth, and they love that. I should have said that earlier. Although I don't do PowerPoints, I do bring in things, bring in sort of web sources when I can, and things that are hot topics to them. And I think Portia and I have talked about this too, not just in the value measurements, and in Doug Rendelman's casebook that I have with him, we do a case called Childs, and it's just about tort damages for wrongful death. And it has, the court was considering studies, and the is battle of the experts, and the studies, some of them are including sort of data that hasn't thought through the structural, race, gender overlays. And it's a nice opportunity to talk about that. And then there are more, I've spent whole classes on reparations conversations, and those are just moments to kind of dig in, get people talking. I usually dovetail it with constructive trust and get them thinking about, how do you solve ancient wrongs? But again, it's taught differently depending upon where I am. At West Virginia, that ended up sort of overlaying with Appalachian coal miners, and when they used to work for coal mines and not really get paid for it. So that was kind of interesting on a class sort of basis. But I think it's always important to figure out how can you incorporate it. At GW, students are very interested in public law. So there's a good way to sort of pull in civil rights conversations across, what are sort of some current claims on those fronts. And I think that's been a good way to do it. But what have others done? I want to hear from that.
Yeah, well, I think this is Tracy again. I mean, I think problems are the way to do it. I mean, they're very easy because you can present it in a safe way. The problem is a news situation, or it's an appellate case. We have, it's also the cases that we choose in our book. We have a public law focus. So we have, I think, 3 different police kind of cases as well. But then we give you problems, but you can add to your problems. But we have a lot of those. And we're now working on the next edition where we're increasing that. Sexual harassment damages, things like that. So the problem gives them, a finite world where then you have to apply the rules, but then you also can bring in these policy issues, so that it's the discussion of these issues are tailored to the course. And that allows, I think, some freedom from the students, but also a way for you to present those issues, in a different, I do the same thing in con law when I teach it. I think it's easier to give them, the cheerleading case of Twitter, which is at the time was the FU case of cheer, which was funny, but a way to get into it in an easier way than just, what do you think of this policy wise? So problems are a great way. And again, our casebook has them, so you don't even have to come up with them if you don't want to. You can use that. And then the answer that, users over the years have put together, or you can adapt your own. I mean, you do have to be careful on these issues. You have to, I think, know what you're talking about and do your own research a little bit on both sides. I do think that, we are generalists in remedies, and I agree with everything everybody said, that we know more than they do, and it's okay. But on some of these issues, First Amendment, religion, gender, race, you're going to get deep discussions, which I like and I want, but you need to understand those parameters and then bring it back to remedies, because I think that gives a good way to structure that discussion.
And I think this is a great place that we're closing out. I want to mention from the chat that Doug Laycock put in the chat to email him if you want the suggestions on answering examination questions. Yes, so I will not add more. I have thoughts on the equity, on how to bring in the diversity stuff, because that's my interest. So I think asking students, I have like maybe 6 hot topics that I ask students in advance which ones they want, and I put those in, and I put articles and cases and supplement in that way. But I have to say, this was just so wonderful. There's a recording. So if anybody wants to kind of go back and see what was here, and I'll save the chat before we exit out of it, in case people wanted access to that information that people had put in here. But thank you to all of the panelists. Thank you to John for putting this together. And I hope everybody has a great day and week, and have a great time teaching remedies, hopefully this year.